Good morning, guys. I am still recovering from my cold. Like, I was out last week. I was so sick all of last week. I'm still recovering, but good morning, everyone. Hopefully, I don't cough too much today. Happy new month, everyone. Happy July. Good morning, Ifemi Oyedele. Thank you. Good morning, Ms. Dam, Sexy Shirt. Good morning, Richard Mason. Good morning, Rashid Coley. Hello. Good morning to Facebook as well. And good morning to YouTube as well, Francisca. Let me introduce myself. My name is Ayesha Chidole. I'm an immigration lawyer. I represent clients all over the United States with their immigration matters. If you'd like to schedule a consultation, you can call our office, 407-995-6567. You can also call our other phone line, 678-325-1037. Or you can send a WhatsApp to 403-333-8751. Good morning, Bella Love. How are you doing? Good morning, Teggy. So today you guys can just jump into questions. Like I said, I am recovering from like a week long of being sick, jet lag, so much going on. So, I'm just pushing through the days. Marva said, good morning, friend in my head. No, we're friends. We're friends. Lovely butterfly, good morning. Someone's asking, I filed an I-751 jointly and waiting. I'm filing for divorce this month. What should I do if I get called for an interview while the divorce is pending? Should I notify USCIS when the divorce is filed? So the thing about when you file for divorce, it means that you have to ask for a waiver of your joint filing of the I-751. Real quick, for those of you that don't know what an I-751 is, it's if you get a 2-year conditional green card, in order to remove the conditions in your green card to get a permanent residence, you have to file for a removal of the conditions, which is the I-751 form, and normally you're supposed to file it with your spouse. If your spouse and you are getting divorced, you have to inform USCIS that you are divorced. If you are in the process of filing for divorce, but the divorce has not been finalized, it's better to wait until the divorce is finalized. Unless you get called for the interview, then you can then let them know that the divorce is pending. The reason why is that you do not want to, because if you have not finalized your divorce and you want to change your application to a waiver for divorce, your application will be denied if you don't have the divorce decree. Oftentimes they may give you 87 days to get a divorce. So unless you know that your divorce will happen within that window, it's better to have your divorce decree in hand and then you notify USCIS. But let me be clear, it is very, very, very important that you notify USCIS when you get divorced if you file for removal of condition. Because if you're divorced before they make a decision on your case, when you go into naturalization, you are going to have a problem. They're going to say that you intentionally misrepresented yourself, meaning you didn't let them know that you and your spouse were no longer together. And so you really weren't eligible for that green card in the first place. So for those of you, because, I've been getting a lot of consults recently where they're like, oh, I want to file for naturalization, but I got my green card after I got divorced, but I never let USCIS know, but they just bypassed that interview. For those people, they're at risk of losing that green card and, of course, being denied naturalization because it wasn't, USCIS was not notified, because that's a critical requirement for it, okay? Bella Love says, are you sick? Well, I'm recovering. I was sick. I'm, in recovery. But thanks for checking. My dad's I-130 and 485 has been pending since 2023. I sent an e-request 2 weeks ago. How soon will I hear from them? If it's been pending since, I'm assuming that the I-130, I-485, I'm assuming that you're a U.S. citizen and you filed for your parent. If it's been pending since 2023, I would consider it to have moved past, a decent timeline, unless there were RFEs that you went back and forth. If that's the case, I don't necessarily know that an e-request would be the best option. The best option would be to ask for congressional assistance, like your state senator or your state congressman, to see what's going on with the case. I don't know if, some of you guys heard, they removed the ombudsman and then they brought it back. But we don't really know whether they were really processing cases, because that realistically would have been the first and best option. Because, when you're dealing with the congressmen or senators, sometimes it depends on if, the senator or congressman's is immigration friendly or not. Like sometimes they don't care. They're not, it's not a priority to them, but the ombudsman is usually an advocate for applicants. But, right now it's all, of course there've been lawsuits filed, it's just kind of in limbo. But that would be what you'll try. And then of course the next thing after that would be to file a writ of mandamus, which is basically a lawsuit suing USCIS, asking them to make a decision on your case. I don't understand this last question. All right, let me move to here. If the abuse happened 10 plus years, are you still qualified for VAWA? So the abuse timeline is not something that disqualifies you for a VAWA application. Whether the abuse happened 10 years ago, 9 years ago, 8 years ago, 2 years ago, when we're looking at a pattern of behavior, because the abuse happened 2 years, 3 years, or 10 years ago doesn't mean the abuse didn't happen. Instead, what they're looking at is, do you meet the requirements of VAWA, which is, I'm just going to assume that this is based on marriage, which is that you are married to a U.S. citizen or a green card holder. You experienced abuse in your relationship in the United States, right? Unless that person was in the military, outside of the country, like the U.S. military of some capacity. You cohabitated at some point before or during marriage. Cohabitation means living together, not like, oh, I visited you for a weekend. Cohabitation means living together. While there's no timeline of how long you should have lived together, but the intent that this was meant to be a permanent situation has to be clear to USCIS to satisfy that. And of course, you have to prove that you're a person of good moral character and that you, don't have any crimes of moral turpitude. So if you have all those things, then you will be eligible for VAWA regardless of the timeline. Okay. All right. So John Kev says, does a pending charge from another country affect a green card application? It could potentially, just depends on what the charge is, if it's a crime of moral turpitude. And then speaking of pending charges, I'm sure you guys may know, you may not know, basically that the House passed, Congress basically passed a bill, voted for a bill where basically if you have a DUI, that can basically get your green card taken away from you or make you ineligible for a green card. Whereas currently, if you have a DUI, it's not necessarily the end all be all of your green card or getting a green card. That being said, it hasn't become law yet because, it still needs to go through the Senate and then the president still has to sign it. But with them passing the Lackney-Riley Act, it is very likely that this could pass. So I say this to say, you really all need to be mindful of making sure that you're not putting yourselves in positions where you're being arrested for any reason or stopped by the cops for any reason for that matter. I mean, apart from the fact that you shouldn't be drinking or being under the influence while you're driving, because it's not only harmful to yourself, it's harmful to others. Just don't put yourself in a position to be stopped by the cops for any reason, okay? Hi, Charmaine. Good morning. Good morning, James. Good morning, Toya. All right, Instagram. Let's see what else y'all got. Okay. How do you handle the delays going on? My I-485 with the I-765 was filed in March, and my current EAD expires on September of 2025. I'm not eligible for automatic EAD renewal as my category is not listed. If you filed your application in March, you are not experiencing any delay. Like, you've not even scratched the surface of the application. March was literally like, 4 months ago or 3 months ago. So you're still in a very, very normal timeline. Delay is like after 9 months. If you submitted your application for an EAD and it's been after 9-10 months, then you'll be talking about delay. You're in a normal processing time, and USCIS is going to process your case normally. If you have a reason why you need to expedite, like, for either like a job offer that you got, like potential eviction, health crises, like those types of things, and you have evidence, you can also request an expedite, and they can either approve it or deny it. But March is still a normal process, timeline. Toya is asking, how long do you see VAWA work permits renewal taking? Majority of cases, it's going to be somewhere between like 6 to 10 months, with the average person with the renewal getting it between like months 6.5 to 8.5 months. That's what we're seeing. Whenever you guys ask me for average timelines, understand that this is just the average, meaning the people in the middle. What that means is you're always going to be people that get it earlier, and there's going to be people that get it later, but this is just the normal timeline. Navia says, my I-130 and I-485 has been pending since 2023, but I've been getting abused. Can I file for VAWA, and how long would it take? I'm very sorry to hear about your abuse. That's horrible. Definitely schedule a consultation so we can screen you for eligibility on VAWA. Because if I don't know the situation, I can't tell you to file for VAWA because I don't know if you're eligible. But if you are eligible for VAWA, usually you can request for an abeyance, which is a continuance, basically saying to USCIS to put your I-485 on hold, to allow you to submit your VAWA, and then you can merge the two, and then they will make a decision on the VAWA, on the I-485 until they approve the VAWA. Abeyance requests are discretionary, meaning they don't have to approve them. If they don't approve them, you can always file a new adjustment of status. Yeah, so you can call the office 678-325-1037 or 407-995-6567, and then we can qualify you to see if you're eligible for VAWA. And one thing that I wanted to talk about in responding to, you asked a question about timeline, is that not only myself, a lot of my colleagues are seeing where people are like, oh, let me file for VAWA, like maybe they filed for VAWA or whatever it is, and with the administration, and just feeling just a general anxiety level, like, oh, I met somebody else, like I want to get married, or this person is saying that they're going to be willing to file for me, blah, 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 etc. One of the things that, I feel like I've talked enough about is that, whenever you have the opportunity to petition by yourself, meaning you're eligible to petition by yourself, you should never rely on somebody else petitioning for you, because the same reason why you're in a situation where you have to file for VAWA, it could happen, because you can't trust that that spouse will not use your immigration status as a weapon, or will not become an abuser, or will not sabotage you at your interview. And understand that now everyone is an enforcement priority. What is an enforcement priority? It means that everyone denied is potentially going to be sent into deportation proceedings. In the previous administration, the enforcement priority truly were people who had criminal records, of any kind, where if you get denied for your marriage-based case, you may not necessarily get a notice to appear in front of an immigration judge if you're squeaky clean, you don't have any criminal records, or whatever the case may be. But now it is a requirement. So you want to make sure that whoever you're marrying, whoever is putting in an application for you, that you have a good faith marriage, and that, this is something that both you and your partner are serious about before you put in that application. Sometimes people will I would see pictures of clients where, and I talk about this a lot, because people are like, oh, do you have pictures over the course of your marriage? And they'll say, I have my wedding pictures, and I'm like, okay, let me see your wedding pictures. And you see a wedding picture, you've got the guy looking casket sharp in his suit, cut his hair, looks great for the wedding. And you have a wife wearing barely didn't comb her hair, wearing a face cap, just a crop top, looking crazy, right? And to me, when I see that, and I'm an attorney, I'm not even the adjudicator, I can't take the marriage seriously, because I'm going to be when USCIS sees this, the first thing they're going to say is this: how can this be a good faith marriage where one spouse is taking their marriage very seriously, which typically is the immigrant, and then the other spouse did not even bother to comb their hair to come to their wedding? So when I say, take your marriage seriously, put your things together seriously, this is a serious thing, you do not want to find yourself in detention. You do not want to find yourself in front of an immigration judge. If you're putting an application, put your packets together properly. Don't get frustrated with your lawyers when they tell you you need X, Y, and Z. The reason why we're telling you you need X, Y, and Z is because we do this day in and day out. We live and breathe immigration. We know what the requirements are. We know the types of RFEs that we see. We know the kinds of people who come to us and what the issues are with their cases. So we're not just saying it to make your life difficult. We're saying it because we want you to be successful in your case. Because what is the point of coming to, I can't speak for any other lawyer, but I am severely competitive. I do not want to lose any of my cases. So if you're coming to me, you better be prepared to win your case. And if that's frustrating that I say, you need to give me this, this, and this for us to win your case, I'm probably not the lawyer for you, because I take my job very seriously, because these are people's lives, lives and families that are separated because of this. It can change the trajectory of many people's lives. And I also think that presentation really matters. How you present yourself before USCIS, whether that's you as an applicant or from me as an attorney, dictates the level of respect I get from an officer. If I come with some sloppy skeletal application, whereas the officer is Aisha, damn well this is a ridiculous application, how can they possibly take my application seriously? So in that regard, you always need to make sure that you are gathering and trying your best to get together what it is that your lawyer is telling you to get to. And if you do consult with the lawyer and you don't meet the requirements, I guess every lawyer is different, in how they break the news. I know for some people are very devastated to find out they may not meet the requirements of something. Use it as an opportunity in those consults to learn, what are the requirements? Is it something that you could potentially meet later? Is it something that you can gather whatever you need? Or should you look for another alternative that you might be eligible for? Okay. All right, so I was previously married in the US, and my ex-husband filed my USA spouse visa petition, but due to some issues, we did divorce, and after a divorce, he canceled my petition. Now I am planning for a second marriage. Will I show my previous marriage-based USA visa petition in my second marriage-based USA spouse visa, including receipt number? I'm not really sure I understand what you're asking me, but you do have to disclose your marriage. USCIS has the information on your marriage if he already filed for you, and usually the applications generally will ask, if they filed for someone before, if someone has filed for you before, so those information, you would have to put that information in there. I filed an I-130 for my parents and sister 3 years ago when my sister was 18. My parents both received their green card this year. However, there's been no update on my sister's application. What should I do? This is actually a very good question because this is something that so many people don't understand how it works. So on a normal basis, everybody considers their sibling to be their immediate family, just like your mother and your father, your immediate family. You know, we've been trained that that's our nuclear family. When it comes to immigration, your siblings are not considered your immediate family because, first of all, you cannot apply for a sibling, right, until you're 21 or over as a U.S. citizen. Siblings have the lowest family preference when it comes to immigration, meaning you're looking at a timeline of 16 to 18 years for your sibling, for your sister that you filed for. However, your parents are immediate relatives. So if you're a US citizen and you're over the age of 21, your parents, you can file for them as immediate relatives. It means that visas are immediately available to them. There is no wait time. There is no, we have to wait on the visa bulletin, but it's not the same with a sibling. The sibling, like I said, you're looking at 16 to 18 years. I haven't checked the visa bulletin actually for July, so I can't tell you offhand the exact wait time depending on the country you're from, but that is why. So what will happen is you're going to get that I-130 decision much closer to when the visa is going to be available. The reason being because, NVC, your I-130 could expire, right? NVC is a National Visa Center. Basically, if there's no activity or you don't let them know you plan to continue the case, it could expire. So in that regard, they don't approve those until it's closer to when a visa is available. So that is the reason why. Okay. Keisha, my father filed for me and I came up on a 1-year green card and he abused me. How can I get my 10-year green card? Keisha, I've never in my life heard of a 1-year green card. I don't know that exists. So I think you're probably making a mistake here. But I would be happy to schedule a consultation with you to find out if what you're saying is that you have a conditional 2-year green card and you're experiencing abuse. Call the office and schedule a consultation. We'll screen you and understand what's happening and then take it from there. Okay. KFAM says, can my parents, new green card holders, file a new application for my sister? Yes, they can, but there is a caveat. So let me tell you what the caveat is. As green card holders, they can file for your sister. However, your sister cannot get married until her process is complete. So let's say your sister is 18 years old right now. Because she's under 21, they can put in the application now. I believe, I'm almost about to log off. I was going to go check the visa bulletin for you, but I can't tell you July's bulletin right now. So I can't tell you what the date is, but from a wait time, it could be like 2-3 years. But again, do not quote me on this because I don't have the bulletin in front of me. The bulletin changes every month. So I don't know what it is. And then, she locks in her age at some point, like when her I-130 is approved, and then that way they can consular process. So realistically, that will be the quickest way for her to get her green card. Now, if one of your parents was a U.S. citizen at this point, before your sister turned 21, then she would be considered an immediate relative to them, and she could file. But yes, your parents filing for her right now will be her best option, and she'll do it very, very quickly since she has 1920. She at least has 3 years before she hits 21, so we can get that, I-130 in, depending on what the visa bulletin is. I'm just going to take one more question, and then I have to jump off. Sorry, Instagram, I feel like I neglected y'all today. Someone's like, can you share more light on asylum cases right now? And I don't do asylum, everyone that follows me knows I don't do asylum at all. So I don't talk about asylum just because it's just not an area that I practice. Well, I hope you guys have an amazing week. Great 4th of July. And I'll talk to you guys next week. All right, guys. Bye.